Good evening, everyone. I'm sorry that I can't be seen today, but I hopefully can be heard. So I would like to welcome everyone to the sexual harassment webinar, which is being run by the ANU College of Law. First of all, I'd like to make a welcome to country and to begin by acknowledging the traditional owners of the land on which Canberra is located, the Ngunnawal people, and pay my respects to their elders past and present. But as we're on Zoom, could I just get you to note the following, that this webinar will be recorded and it will be available after the event. The chat function has been disabled, but to submit a question, click on the Q&A button at the bottom of the screen, and there will be a Q&A session at 7:30. I would like to introduce our two esteemed speakers. First of all, Kate Jenkins, the Sex Discrimination Commissioner, who's responsible for the recent very significant and comprehensive report on sexual harassment, Respect at Work, which is likely to become an international model. And also Kieran Pender of the International Bar Association, who has also conducted a very significant international report, #MeToo. In addition to his IBA work, Kieran is also a visiting fellow at the Centre for International and Public Law in the ANU College of Law. So thank you. So I'd like to make a few preliminary remarks to set the scene before handing over to our guests. Now, sexual harassment has been a corollary of women's paid work, probably forever. But the first accounts were included in 18th century novels, such as Richardson's Pamela, when empathy began to be expressed for vulnerable young women, particularly domestic servants. However, the term sexual harassment is much more recent and emerged only about 40 years ago, when it was first recognized as a form of sex discrimination in North America. Now, a teacher of mine at Yale Law School was Catherine McKinnon, and she was responsible for the most influential book, The Sexual Harassment of Working Women, which was published in 1979. Sexual harassment was recognized as sex discrimination soon afterwards in Australia. In 1984, O'Callaghan and Loader was a case heard by the Equal Opportunity Tribunal in New South Wales. Justice Matthews then canvassed the Canadian and American case law and accepted that sexual harassment was a form of sex discrimination. However, she declined to find in favour of the complainant, who did not make clear to the respondent that his overtures were unwelcome. However, the power disparity between them was striking. Miss O'Callaghan was a lift driver, and such a creature doesn't exist anymore, and Mr. Loader was the Commissioner of Main Roads, a statutory position, so they couldn't have been further apart. And retaining her job was contingent on his approval. However, there was a positive that emanated from that decision because the decision coincided with the drafting of Susan Ryan's federal sex discrimination bill. And as a result, sexual harassment was included and acknowledged to be a form of sex discrimination. The Sex Discrimination Act of 1984, which we're going to hear more about. However, many sections of the public, including lawyers and employers, were slow to recognise sexual harassment as a harm. This included judges. For example, in Hall and Sheban in 1989, Justice Einfeld dismissed a complaint by 3 receptionists who had all been inappropriately touched by their employer, an elderly doctor. The judge held that his actions were, quote, explicable in terms of the doctor's tactile and amorous impulses, close quote, although the decision was overturned on appeal. Nevertheless, judges, although they became somewhat more receptive to sexual harassment, only awarded token damages, if at all. And this was the case until relatively recently, when Justice Kenny in Oracle and Richardson drew attention to the anomalous undervaluation of the harm of sexual harassment compared with damages awards in other areas of law, such as defamation. We were familiar with politicians, for example, receiving very substantial payouts. Only this year in Hughes and Hill, an award of $120,000 in general damages and $50,000 in aggravated damages was upheld on appeal to the federal court. Now, aggravated damages are compensatory and are awarded in circumstances that recognize the distinctive nature of the injury to the complainant. Ms. Hill was a paralegal subjected to sustained sexual harassment and psychological trauma by her employer, a country solicitor. Now, as most complaints of sexual harassment are not dealt with publicly before tribunals or courts, but are dealt with behind closed doors through the process of conciliation, which is an informal method of dispute resolution. But as a result, we know little about either the facts of a complaint, the process, or the outcome. And furthermore, if damages are agreed to, the complainant is usually required to sign a non-disclosure agreement. So in fact, only about 2% of complaints are heard by a tribunal or court. So it's a very small percentage. And we know the outcomes of these cases because, as I said, that they are heard publicly. However, few of these decisions are reported by the media, although reporting can have an important educative effect. Now, in an age of preoccupation with celebrity scandal, there is then a focus on high-profile figures, such as appellate court judges, and there were the cases of Clarence Thomas some years ago in the American Supreme Court, followed by Brett Kavanaugh more recently. And in Australia, we've had the recent case of Dyson Heydon, a former High Court judge. The movie mogul Harvey Weinstein is probably the best known sexual harasser in the world, and many of his victims were also well-known film stars. This case had extraordinary global impact that gave rise to the hashtag #MeToo movement. In turn, this led to various reports that attested to the exceptionally high rates of sexual harassment in workplaces everywhere, involving men as well as women. Nevertheless, while the hashtag #MeToo movement was a positive corollary of the Weinstein case, the downside of focusing on high-profile harassers is that it deflects attention from ordinary, everyday instances of sexual harassment in the office or the factory, as well as a wide range of behaviours in which sex-based discrimination is systemic. Such behaviour usually falls short of legally cognizable sexual harassment, but creates the conditions that contribute to the harassment. So just to mention several of those, first of all, bullying, which we all understand from our school days, which may include excessive criticism of work performance and so on. But that is now unlawful under the Fair Work Act, so it's dealt with separately. And that's the case since 2014. But it nevertheless can be systemic and affect and be related to productivity in a workplace. For example, a Harvard study of 50,000 workers just a few years ago revealed that management tolerated high achievers who were toxic workers because they were productive and contributed to profits. Then we have the instance, which is very common, of gender disparagement, which includes verbal put-downs and disparaging remarks about women, about their ability, about their looks, their clothes, and so on. In one of the early sexual harassment decisions in New South Wales, Hill and Water Resources Commission, 1985, the then New South Wales Equal Opportunity Tribunal, upheld a finding of sex-based discrimination against a group of men who engaged in petty harassment of a woman who had moved into a minor supervisory role. The fact that she was in the supervisory role upset them. Their behaviour included nuisance telephone calls, unpleasant jokes, and so on, which caused the woman to have a nervous breakdown. However, because this behaviour was not explicitly sexual, it is unlikely that it would satisfy the test of sexual harassment under the Sex Discrimination Act. The systemic element underpinning sexual harassment then can be understood more clearly, I suggest, that if we think of work as a masculinity contest, in which men work long hours, vie for high status, power and privileges in competitive, hyper-masculinist corporate cultures. These men want to secure dominance over others, over men as well as women, to prove their manhood, their superiority. They may engage in sexualized banter, and while perhaps not illegal according to the requirements of sexual harassment, this behavior nevertheless can create conditions in which problematic sexualized behavior takes place. So changing workplace culture then is difficult, particularly when it is part of the broader culture in society. I would therefore be interested to hear from Kate and Kieran whether the positive duty on employers proposed in the Respect at Work report might have the potential to change prevailing leadership models and workplace cultures. Thank you. I will now hand it over to Kate and Kieran. Thank you.
Thank you, Margaret, and it's a real honour to have you providing some opening contextual remarks for us. Margaret has really been at the forefront of research in this field for many decades, so it's fantastic to have your insight. And Kate and I did think that your webcam difficulties did lend a degree of mysteriousness to your remarks. I wanted to begin by acknowledging the traditional owners of the land which I'm on, and begin also with a bit of a content warning that some of what we discuss today might contains self-evidently, given the title of the topic, issues to do with sexual violence. And if anyone feels the need to leave the webinar, please do so and seek appropriate support. Really honoured today to be joined by Kate Jenkins, the Australian Sex Discrimination Commissioner, who has led a really global, landmark, world-leading international Australian inquiry into workplace sexual harassment. And I'm really excited to elicit from her insight from that journey and a sense of what comes next. If at any point you have questions, please put them in the Q&A box and we'll get to them at the end of the session. Just a bit of context from my behalf, in addition to being a visiting fellow at the ANU, I joined the International Bar Association in London, which is the peak global body for lawyers, about 3 years ago. And if I can begin with an admission, I must say that when I joined, sexual harassment and bullying were not particular areas of specialty for me. I did have a background in employment law and so had an understanding of the areas, but I certainly wasn't like Margaret, an expert in this field. And I joined the IBA predominantly to work on whistleblowing. And on my second day at work, I was handed a report the IBA had written entitled Women in Commercial Legal Practice. And I was told that the report and the next steps from that report were now my responsibility. And I remember at the time, and I admit this to sort of provide some insight into the journey I've personally gone on this campaign. I admit to thinking, well, I'm not a woman and I'm no longer in commercial legal practice, so what does this have to do with me? And I remember, it's a bit cliched, but one of my interns at the time suggested to me I read a book by a Nigerian author called We Should All Be Feminists. And that book and also the report that I'd been given responsibility for carrying forward both made the point that these issues are workplace issues, they're societal issues, and they are very much not women's issues. And so it's incumbent on everyone, and I would say particularly on men, to drive this campaign forward. So in the subsequent 3 years, I've led the International Bar Association's work to address sexual harassment and bullying in the legal profession. And we've published a major report called Us Too on that topic, and conducted an international campaign. So I guess I wanted to begin, Kate, by asking you, before we get into the bigger picture questions about your personal journey. You, for several decades, were a partner at a big international law firm. That's a sector that's had its fair share of sexual harassment scandals. I know that you personally were involved in sexual harassment training for the firm, for clients. Now, I imagine that no career trajectory while you're on it feels linear, but now you are where you are. Do you feel as if you were always destined for a role such as that you currently have?
Well, I feel like I was well placed to do this job, and particularly to focus on sexual harassment really well. If I think it's easy to look back and then piece it together, and there's a lot of logic in a sense. But if I, when I think about that question, if I think of when I was at school, there's one of the, it's not a sexual harassment story, but I've worked out at 79, I was in grade 6. And I had a really strong sense about the story of Deborah Wardley, who was this aeroplane pilot who wanted to fly a plane, and Reg Ansett basically said, no, because you're a woman. And I guess it made the papers quite a lot. She was the first case in Victoria of sex discrimination. But even then I was like outraged that I had two brothers, why, like it just was incomprehensible. And in fact, I still find sex discrimination incomprehensible, but we still experience it. But then when I think of jump forward, I was at uni at the time when the Sex Discrimination Act came out, and, we got to see those commissioners come through. And I was saying to Margaret, I did feminist legal theory and discrimination law, but it was brand new. We were learning about new laws. Then I lived in Ormond College. So some of you might know there was a sexual harassment issue at Ormond College that was thereabouts. And then I ended up in this law firm with no intention to work in a commercial firm, but certainly the need to do my articles and to get some experience and to start my life. And I ended up in their employment practice. And that story is 20 years later, I was still in their employment practice. But that was early 90s to, 2013. And the story of that professional, like this conversation that we're going to have, it will be laced with what I saw in the change over that time when I started. And you said, I drafted the first sexual harassment policy for so many corporates. I was the only person doing this work. None of the guys in my work or actually at any of the firms wanted to do this work. So in reality, my career success was off the back of people not wanting to do this work. But I did cases over time. I did training. I advised, I did all the different aspects of this. And then jump forward to 20 years. It's a perfect time. And maybe I'd recommend people might leave a bit earlier, but it took me that long that I became the Victorian Human Rights Commissioner, did a big review of Victoria Police on this topic, and then ended in this role. So in that, Margaret's described that 5th of October 2017, just that day, I became really convinced that, well, actually that day, but then for the next few months, it was a different conversation. And I suddenly thought, I'm in this role and it's time that we think differently. And fortunately, Kelly O'Dwyer was the Minister for Women, who really agreed that it was time to look at sexual harassment and come up with some better solutions. It hadn't worked. So on that piece of work, I think a lot of things has pointed me to this point.
And it's great to see a copy of your report behind you.
And you would, I'm not meant to jump out of screen, but you would know this is the actual one I use. That's the show copy. And I'm really glad I brought down 2 copies because it got tabled. It was literally delivered and tabled in Parliament on the 5th of March. And I was last in my office in Sydney on the 17th of March. And I just put 2 of these brick heavy books in my carry-on. And thank goodness I did. So I've relied on these 2 copies ever since.
My report was only 130 pages long. I think yours is almost 1,000. So I feel I had more writing I should have done. Before we sort of get into it, I just wanted to also get at the institutional context. Obviously you've given new momentum to the Human Rights Commission's work in this space, but it has been doing work in this area for a long time now. Can you maybe just tell us a bit about that?
Yes, it's really interesting. I look at the history of the Commission, and when the Sex Discrimination Act came in 1984, I think every single sex discrimination commissioner since then has identified sexual harassment as one of their priority issues. I think so there has been campaigns and education resources over time in those earlier commissioners, but it was Prue Goward who in 2003 decided, and she's told me, and I think this is right, sort of the inquiry kind of was the almost inevitable endpoint. So she just did a tiny little survey that was a telephone survey of a couple of thousand people on sexual harassment across the country. What she said is that she thought if we start collecting this and can collect it over time, we'll really know what is happening. So that was in 2003. There was another survey in 2008, one in 2012. And our next survey, so Me Too happened just before our next survey was due to happen in 2018. So they're like any change. And in fact, I've learnt so much in this job, but there is a lot of things we need to change. There's social, there's human rights issues everywhere, but you do need a combination of the time being right, the government, the community interest, and definitely the Commission. I'd come from one direction, but the Commission was absolutely ready for this piece of work as well. And at a moment where people were keen to listen, which I don't think was true just because there wasn't this sense of the problem, I don't think. I think to some we knew there was a problem, but many people it was just invisible. And I think you know that on the work you've done over the last 3 years in particular.
Now, we're both Australian, and I think this is a predominantly Australian audience, although I did bully some of my colleagues in London to wake up early to attend. My research thus to report, we did a global survey of about 7,000 lawyers around the world, and we had quite a lot of responses from Australia. And our data showed that Australia had a significantly higher rate of sexual harassment and bullying in the legal profession than other countries around the world. Australia had some of the worst rates in terms of prevalence. Now, there's various methodological caveats that I added to that in the report, but when it came out, there was a lot of resistance to that idea. I remember the Australian newspaper had a headline, sort of Australian lawyers worse than Russians in terms of sexual harassment. And when as part of our campaign, we went to about 30 cities around the world and held events and roundtables. And when I came to Australia, there were some people who weren't very happy with me and with what my data seemed to show. Now, are you right in your report that Australia used to be at the forefront of tackling sexual harassment globally, but now lags behind other countries? What has changed? Why do you think that is? And do you think Australian workplaces are better or worse than other countries?
Yeah, well, it's definitely, sexual harassment is definitely a global problem. So while I think, and I think this, that industry-specific data is incredibly valuable, because everyone thinks when you say it's 1 in 3 Australian workers, almost everyone thinks it's, gosh, there must be some terrible workplaces out there because it's not happening in my workplace. So first and foremost, that research is critical. And there, in terms of the national survey, we are unique in doing something that captures the whole country. When we looked across the world, it's mostly in particular industries where there might be survey work, and it's very unusual. That's why your piece of work was fantastic, to do a truly global piece of work to get that real comparison. I would say one is, I think that the Me Too movement was global for a reason. That our world still, so our finding in the inquiry was we were looking at drivers of sexual harassment, and I'm sure we'll get to, and you and I are particularly interested in or have personal knowledge of the drivers in the legal profession. But when you look at them, the overarching driver that we found was power disparity and the single most consistent power disparity across this country and actually across the world is gender inequality. So I would say that on one hand, without the comparison, I would say, look, actually lots of countries are quite bad. There wasn't a country you could go to that it was free from sexual harassment. But if I think of our gender inequality issues and sexual harassment in Australia and what I heard through the inquiry, I would say as a country, we started really well. We started out, we had Sex Discrimination Act, you've got my position, we've got some really good laws, we've got even to now some really good structures, we've got an ambassador for women in STEM, like there's some really pretty revolutionary things. The Workplace Gender Equality Agency is really world leading. So we introduced those laws in 1984, and we definitely have progressed hugely on educating women and girls, so particularly through university. But when it comes to workplaces and in the home, there is still very strong stereotypes in Australia about what men and women do, what their roles are, what they're good at, and what they're not good at. And I would say, if I think of your results, I know when I was as a corporate lawyer, I used to do, if there were expats, particularly that would come from the US, they would come to Australia and I would give them a briefing of the employment laws. And I remember they used to say, and it was more than one, would say, there are no, I can't believe there's no discrimination laws here. And I'm like, no, we have discrimination laws. And they're like, I was in the boardroom, the language was, you know, there's very kind of sexist language I've heard, you know, and they would like, how are people behaving this way? And I've had that even more recently, some American executives saying, sitting in a room of, particularly a room of men here, there's kind of some sort of odd bonding kind of, no one calls anyone out and everyone kind of, you know, I've never heard the masculinity contest and I'm not kind of jumping right onto it. But that idea of our culture here about women, you know, women will take leave and they will look after the kids and men should be the primary breadwinner. So that's a big question, but I think that's still quite fundamental in a lot of both our attitudes, but our policy settings. And so I think that does affect the workplace. I mean, as a general rule, almost all industries have still men in the majority at the top, even female dominated industries. We definitely found that made a difference so those gender segregated industries had higher rates of sexual harassment. And we also, I mean, one of the most interesting things, and that's why I particularly love your work, is that for the first time we broke down industry data. So we could, using the 21 ABS industry divisions, we could tell you what it's like in mining, what it's like in construction. And so people who'd really said it's not in my workplace had to come back and say, well, it is, and this is what it looks like in my workplace. Mm-hmm. So those are some of the reflections. We did look globally, and other than yours, there wasn't really nice, perfect comparison. But when I read internationally, our experience, and particularly in Western democracies, looks very similar. And I think the other risk factor that we've got that's increased is, so gender equality hasn't progressed as much as I think we expected. And I think a big driver behind that is our laws are driven by complaints. There's no proactive positive duty that Margaret mentioned. But the reality is, a culture, we're not ones who, you get along, you take a joke and you don't complain. You don't want to be a whinger, and it's too small a country to make enemies in different industries. So that's really critical as well. And then the other thing that's going on right now is just the insecurity of work that during the inquiry showed our work is done so differently. So when the laws came in, you know, you worked for one workplace and you went there and it was very simple. The laws worked really well. Jump forward to now in the legal profession. If we start there, you've got barristers being briefed by lawyers who have clients and appearing before judges, and not one of them has a direct employment relationship. Some of them are covered, some of them are not covered. It's complicated now how we work. And when you have laws that are designed around very rigid structures, it sort of has gone the other way. Everyone's just thrown up their hands. It's too hard. I won't answer them all this extensively, Kieran. I'll try and keep
And I mean, on that direct point, I think you saw with the Dyson Heydon issue, some of the legal nuance around whether associates are protected from sexual harassment under the SDA, you know, raise really complex issues, which shouldn't really be complex. You know, a High Court judge shouldn't be able to sexually harass lawfully their associate, and yet there are open questions there. My only other comment is on the data, and I think, you know, you and I are both firm believers in data, or data, as our international friends would say. But yet, notwithstanding that your data, my data shows prevalence is, you know, a huge, undeniable problem, I still found it really eye-opening that I would go into rooms with sort of round tables of partners at law firms and present them our data, you know, for their country or their region or whatever. And they would still look at it and then look out the window, and I could just see them thinking, oh, that law firm across the road must have a real harassment problem because, you know, we don't, and how can this data be right? Which leads me onto my next question in terms of the process. You know, your national inquiry it was a fantastic piece of work. You took your time, you did it right, and it was grounded in stakeholder consultations. Can you tell me a little bit about that, and particularly interested in, you know, the benefits and the challenges, and, you know, were there any light bulb moments, or was it sort of just a steady accumulation of insight?
Yeah, we had the survey, and then we accepted submissions, and we got 460 submissions, and about 100 of those were from organisations you know, law councils and that sort of thing, but the rest were individual stories. So I heard those stories, both the experiences, both through those submissions and in the consultations. We did 60 consultations across the country, all major cities, and about 4 or 5 regional centres. And I would say, I mean, we all know this, so we don't want to have to put people through telling their story to make change, but what I do think it was the layer upon layer for me. Most of those stories, and I call them stories, and there's experiences that I heard, were the same experiences I'd heard in my legal practice, which had a lot of sexual harassment cases. So I was dismayed about how little had changed. But I also remember I did the very first sessions in Hobart, and you know what I heard in Hobart, everyone thinks they're in a different industry or a different location, but actually the stories were so similar. So and people, the process, both for me, a couple of things. So the experiences did match what I knew, but it was really helpful to hear them. And the report really tells some of those stories to remind people of the reality of what we're talking about. But the one thing I know, when people say, you know, I'm the only one who says, when another sexual harassment case is reported in the paper and everyone says, are you shocked? And I say no, because I read it and it's just every kind of, they're all similar. But what I did, by the end, the realization, well, 2 things. One is I realized no matter where you are, no matter what level you are, and no matter what industry, sexual harassment happens. You don't want to complain about it, and to do so, you know, we're small industries, even Canberra. So, you know, the woman working in health in Hobart said, when this is over, I'm going to have to leave Hobart. Then you talk to someone in Darwin who says, I can't alienate myself from my community, so I can't complain. Then you speak to a public servant in Canberra who says, I can't, you know, make a complaint. So it doesn't matter where you are in Australia. So that was one thing. And the other just was the long-term impact of sexual harassment. So we did, I think, you know, we, Deloitte Access Economics did some economic modelling for the inquiry on the cost of sexual harassment. And they estimated to the Australian economy, it cost $3.8 billion in 2018. But their measure was really on that year. When the complaint comes up, you know, what it costs, what's some medicals, what are the legals, you know, what's the lost productivity. But the people I was hearing from was, some of them were telling me their experiences 5, 10, 15, 20 years before. And they were also telling us about the injustice of how poorly it was handled. They were telling me about how they hadn't been able to continue working in that workplace, but also that industry, how they had never worked, you know, reached the potential. So the tale of this, we talk about it as if it's something that just happens and you're done with. But the reality is, some people come through it, but for a lot of people, the poor handling of sexual harassment, it's not only mental health, it's an economic consequence. People really never achieve the earning capacity or the career success because they left their industries. Mm-hmm. So that second point really struck me. And I guess the third, I'm adding to it, but was a little bit, and I've got my books behind me, but she said, and me thinking about that institutional compliance and the institutional role in a complaint coming forward, and now we're going to do an investigation and it'll just take 6 weeks and then we're going to make a decision, and then how institutions silence people and really contributed to the pain and the waste and the, you know, ruined careers, even though there were lawyers and everyone thought they were doing the right thing. And so that was a real light bulb for me, having been an advisor.
Thanks. I'm sure a lot of fantastic insight along the way. You know, I think your point about the economic toll and the human toll, I mean, you only have to look at the Dyson Heydon case, and the people who were willing to come forward and put their names to it in the media were people who had left the law, you know, who had been sort of the bright talent of the next generation as High Court associates. You know, any lawyers on this webinar will know how coveted a role like that is. And the people who put their names forward in the media were those who'd left the law. And you know, what a loss for the law. I remember we had an event in Edinburgh last year, and the managing partner of the biggest law firm in Scotland was on the panel. And he was actually talking about bullying, but I think it sort of applies. And he said he'd been bullied every day for the first 3 months of his career, and he was about to leave the law when the partner that was bullying him left. And I remember at first I thought, well, you know, that's fantastic that he didn't leave. And then he went on to become, you know, one of the most prominent lawyers in Scotland. And then I thought to myself, how many people like that are there that didn't have that stroke of fortune and have, you know, and what's the social and economic and professional cost of that? The only other sort of piece of aha wisdom I had on the campaign, I was in New Zealand and was speaking. New Zealand had a big sexual harassment scandal, as I'm sure you know, Kate, in their legal profession a few years ago. And was speaking to one firm who told me about how in response they'd scrapped their harassment policy and begun again with every member of the firm of maybe 300 people involved. And that to me was a real light bulb moment, because they said at the end of the process, it took a time, it was really hard, but people had bought in. I think, you know, we talk about, and we'll probably come on to the role of leadership, and leadership is so important, but we don't create change from the top down without that sort of bottom up involvement as well. And I guess it's about how you harness both. I want to come on to strategies for change in a moment, but just to begin on a more negative note, what sort of resistance have you faced? You know, have you had a lot of pushback to your work, you know, so far, and you know, where's that come from?
Yeah, I think the combination of the Me Too factor and having government support and having workplaces or employers recognising that this is a problem that they needed to do something about. And I think this year that's escalated with the media reporting. There's this sudden realisation that investors won't put up with this, workers won't put up with this, customers won't put up with this, so maybe we do need to do something about this. So from that extent, we always said we're not, where everything we publish will be de-identified, we're not taking complaints, we're not looking for the bad guys. That gave a lot of confidence in the process. That being said, there's probably two places that I don't think resistance is right, but no engagement, and I'd be interested in your experience on this. One was generally from men. So you started with that comment about what's your role, and I think that's very much the view is sexual harassment is something that that's a women's issue. And so I was doing these consultations across the country, and I realized, I mean, we were getting some men, you know, we did focus groups on a whole lot of different topics, and you often, if you did managers, you got some men, and we definitely got a few male victims, and we know 26% of the 5-year sexual harassment experience is men. So we know it happens. And I did have this recognition at some point that, so men are being harassed. They're 4 out of 5 of the perpetrators of sexual harassment. They're bystanders and they're managers, and they're more likely to be the CEO. And yet they weren't participating. And so what I did then was I did a bit of social media to say, come on, guys, come on down. But I actually asked a few CEOs I knew in a few different industries to conduct some all-male roundtables. And what I would say is I heard, and it's really influenced how I think about this topic, is that talking to a group of men about sexual harassment is so different to talking to a group of women. And so whilst generally speaking, a lot of work that I do, I wouldn't say divvy them up, and I don't say that across the board, but I did have some really engaging conversations, and I just start with, this is what sexual harassment is. And from there, men were going, oh, how does that work? You know, like there was some really fundamental, now, and I'm not criticizing the men. What I became apparent was women have experienced sexual harassment. The odds are they've experienced sex discrimination and sexual harassment. You didn't need to explain the difference between a creepy hug and a friendly hug. You know, kind of there's something intuitively in women in this workplace experience. For men, there was confusion. They were their questions about, well, what do you do if you see it? So a manager, if I see it, do I speak to him? Do I speak to her? Do I do it then? You know, there was just sort of so many things going around, but also clearly what is normally happening is a fear to discuss it. So a lack of learning. So I would say that was one, not exactly resistance, but a group that hadn't engaged and that we really need to engage. And the second was, I definitely got resistance when we realised in quite soon after opening that there was one group of people that couldn't contribute to the inquiry, and they were people who'd had a complaint and ended a non-disclosure agreement or were under confidentiality obligations. And so we started looking, and we don't have powers of the Royal Commission, and so we couldn't compel, you know, we couldn't open the pathway, and we looked legislative change, it wasn't going to happen fast. So we asked workplaces, as had happened for the Royal Commission on Child Institutional Sex Abuse and the Banking Royal Commission, that employers had waived and allowed people to talk to those commissions. So I naively sort of write to a whole lot of employer associations and do quite a widespread, basically saying, employers, could you agree to waive your NDAs to let people talk to us? Only for that purpose. They don't have to tell me who you are, just so we can hear their experience, because it felt like it was going to be a big gap. And that caused a lot of unhappy CEOs. And actually I learned a lot, I'm not being critical, how much the system relied on that confidentiality and how difficult it was to sort of be prepared to be vulnerable in that way and let people talk to us. And about 35 organisations absolutely did. And I give them great credit, and they're still listed on our website. But I wouldn't quickly criticise the others, because this is an area where we've been operating in a particular way for a long time. I was really shocked, so maybe I was a bit naive, like, trust me, it's me, you know. But that was the other place where just the corporate discomfort about having this, even to talk privately, that was there. And I think we're seeing that you watch the media, and there's a lot of, there's a lot of anguish caused by having these and reputational damage.
I definitely agree with the male only aspect. I certainly thought that speaking to senior members of the legal profession who are predominantly male still, unfortunately, they responded and engaged with me differently because of my gender. And it was really interesting. I guess at first, I heard a lot about the Me Too backlash. I had a lot of senior male lawyers around the world say to me, well, I'm afraid of going in a cab with my junior associate, or going on work travel with them, or mentoring them. And at first, my reaction to that was, well, don't sexually harass them and you don't have a problem. And I really had no sympathy for that view. As that evolved, and I kept on speaking to more and more people and hearing the same thing, and it really hit me in Melbourne, speaking to a partner who was on their firm's diversity and inclusion committee, and they told me how they were nervous about where the boundaries were these days. And I guess it shifted my mindset, and that's irrational because the data shows that false reporting is almost negligible. So if you're worried about a false sexual harassment complaint, that is sort of empirically not something to be worried about. But they genuinely are fearful of this change and of this Me Too movement. And I guess what it sort of told me was that dismissing that fear won't get them on board in this campaign, and telling them they're stupid won't help. And we need to engage genuinely with the fear. And that's hard because you don't want to give it sort of oxygen because it's not a genuine fear. Yes, false reports happen, but they're very, very, very rare. But how do you sort of engage constructively with that? I want to come on to macro and then micro strategies for change. So to begin at the sort of bigger picture level, your report talks about a legislative reform, particularly to the Sex Discrimination Act. Why do we need reform?
So what we found, we looked at the laws, and the Sex Discrimination Act is still the central piece. And then in Australia, we have the state legislation. But we also found that the safety regime was relevant, even though it hasn't really been enlivened. The reality is the prohibition on ensure or requirement that you provide a safe workplace would include preventing sexual harassment. So we looked at that, and then we also heard very loud and clear, and I know the legal sector is really much more engaged in the Fair Work Commission now. So we found that the safety, fair work and human rights or discrimination laws were very much all at play. So the package of law reforms we actually identified that they all had a purpose. They didn't all talk to each other in a way that made sense. So the definition of sexual harassment, Fair Work didn't have it doesn't prohibit sexual harassment, but people would get in there from other different ways. So the reforms partly are to combine those, to make those laws work together. So it's not confusing for individuals and for employers. But particularly in the Sex Discrimination Act, there's a few I've already talked about, tidying up coverage to make sure you do capture those people that might fall through the gaps and make it clearer and simpler. But the one was really the positive duty that we introduced. So I've talked to you about, our system is the Sex Discrimination Act prohibits sexual harassment, and then the enforcement mechanism is if someone complains. You can complain about the person that harassed you and your employer, for example. And then the way the law then works is if the employer can show they've taken reasonable steps to prevent it, then they can get out of liability. So the reality is the system, one, relied on the bravery of the powerful person in the mix, the victim, and often ended up suing their own employer, who obviously had the resources. And the employer could say, well, you got harassed, but it's not our fault. So the compliance mechanisms were usually, you have a policy, you run training, and you have a complaints procedure, and we might get to those. But the reality is none of those steps were actually preventing sexual harassment. And so the recommendation that we introduce a positive duty in the Sex Discrimination Act was just to say, we're saying people shouldn't experience sexual harassment at work. And so why are we then saying, but you'll only kind of get justice if it's already happened to you? We should be putting the responsibility on the employers. So that was the sort of the most significant reform. Certainly already safety regulators have started to engage and are drafting guidance and toolkits, which is really helpful, and talking to lots of different, talking to us. And so that's really good. But that was that big reform, which is really to shift the focus from complainants complaining to employers providing safe workplaces.
Fantastic. You touched there on training, and I want to sort of talk about a particular type of training that's a bit of a hot topic at the moment, which is sort of bystander intervention training. I guess that's probably the flavour of the month at the moment. Is that the panacea that we need?
it is, and it's particularly the flavour of the month in the legal sector. If you've, I don't know, Kieran, whether you've heard me talk about this before, but even the whole time I was even, you know, working in a law firm, I used to do the training then for partners, and, you know, and I remember partners would, one of the older guy partners was standing up beside me going, we must call this out. This must not happen. And I'm thinking it happens all the time, including with you, and we must call it out. So there's some sort of myth about the fact that if you declare it out loud, it will stop. And even if you're a powerful person declaring it out loud. So there's a couple of things on training. I'll come to bystander, but the broad training, there's research out of the US now that's really helpful that explains to us perhaps why the training that we have been doing, you know, online or once every 2 years simply hasn't worked. And they call that prohibitive training. So we're going to tell you what sexual harassment is. You mustn't do it. If you do, you're going to get in trouble. And if it happens to you, you must complain, you know, if you want to get something to happen. So what the research says is women find that quite useful because they're like, great, at last everyone's clear. Men can waver between two things. Men who are not sexist will go, oh, well, that's useful. I sort of knew it. They're sort of neutral. But men who are prone to sexual harassment, we now learn, might leave those sessions even more determined and more equipped to sexually harass because they don't like being told what to do and a whole lot of things. Now, bystander training, so this really sends me off because particularly in the legal profession, that's been viewed as, wow, this is the great new thing. So there are some things I like about it. So I'll tell you, we'll get to that. But the first, what we're doing in terms of thinking about industries and sexual harassment, the first and foremost thing is to realize it's not just about some individual misconduct. It's a systemic issue that happens across the board. And power disparity is one of the key drivers. So if power disparity is a key driver, then, and I see this in law all the time, then training all the junior associates on how to be good bystanders to each other is fundamentally not going to work because they can't speak up against the High Court judge either. So having good bystander training with the idea of, right, I can abdicate my leadership responsibility because you'll sort it out, you know, when it happens, you'll speak up and everyone will change their behaviour, is fundamentally flawed. However, I do like the idea of bystander training, but actually what I think of it as is really it's almost management training. So these men who I was in the room with were saying, when it happens, what do I do? Do I speak up? So what we know is bystanders will act when they know what the conduct is and they know what to do. And my sense is lots of managers, lots of line managers, like HR might have a view, but most people, sexual harassment happens and involves their boss is in the field, that they need to know better what to do. So I like bystander training, but not to train all the most junior people how to help each other, or at least not that alone. It's the role of leadership to really be changing cultures and to be more informed.
And I'm probably being a bit unfair to bystander intervention training by sort of putting up this straw person of the panacea. I think to me, you know, this is a many piece jigsaw puzzle, and bystander intervention and other forms of training and other initiatives as well, they're all bits of a puzzle, and we need many puzzle pieces to go in. A few more questions and then I'll wrap up and ask some. We've got a lot of Q&A coming in, so I better get to that in a minute. And the first, and Margaret touched on this, which is that the high profile cases, the cases that make the news, Heydon, Weinstein, AMP, etc., they are typically at the more severe end of the spectrum of conduct. And obviously that's deplorable and it's wrong and it shouldn't be tolerated. But your research, my research, other research shows that the more common form of sexual harassment, the more prevalent form is not that, but it is everyday, latent, underlying sexual harassment that, you know, perhaps doesn't get the headlines, but in many cases is just as corrosive, just as problematic, just as impactful on people but it isn't sort of Weinstein-esque. And so I wanted to ask you, how do we deal with that? Because, to me, I think in the campaign, I saw probably a lot of people thinking to themselves, well, I'm not Weinstein, I'm not Heydon, that's not my conduct. I don't, grope my assistant at the Christmas party. But those people may well have been making sexist put downs and not perhaps realizing it, because that's not what's sort of in the newspapers. How do we address that more insidious harassment?
Yeah, it's a great question, because I think that's a lot of why we've kind of got in a tangle in Australia. There is this view that the word sexual harassment is really equivalent to sexual assault. And I would put Weinstein separate to almost all of those. Those were rape, those were false imprisonment. And so but that he could, kind of do that in such a repeated predatory way over time, that made the paper because of who he was. And then the conduct was shocking. You're absolutely right that the majority of sexual harassment is unwanted, sexual jokes, comments about people's appearances, touching, kissing, sexual comments. So the survey tells us those are quite high, and there's a very low chance of people reporting those. And of the more serious sort of rape end of the spectrum, much higher chance that people report. Two thoughts I've got about that. One is that in the inquiry, what I heard quite consistently was that individuals, and particularly women in male-dominated industries, said, look, we just want this low-level everyday stuff to stop. It's just like, kind of water torture, dripping tap, it's just at you. And I remember one woman saying, when you finally crack, like when you're like, do not say that, they all think you're a lunatic because you've been fine with sexist and sexual comments and jokes and, whatever for all this time. And so what I heard consistently, and we came up with recommendations about reporting, is sort of that you can either do nothing or you can go atomic, and there's not any options in between. So sexual harassment is all this conduct, but the reality is it's only when it gets so bad. And then when it does, you end up in some major legal adversarial kind of 6 month, 6 week, whatever it is, QC, we know the formula. So our recommendation was to find many more nuanced options in the middle, including anonymous reporting, to let people come forward. The second comment I would make is about who makes the papers, because I think some of them, like I have a bit of a formula on, and having been a lawyer and having watched, because those awards that Margaret mentioned were quite low in the past, I think originally everyone was panicked. Certainly my clients were panicked about the legal claims, and then they realized if you've got more money than they do, you can settle, or you can, kind of, and the awards are pretty pathetic. And then in about 2000, the media started coming into play. And so whilst the case wasn't too bad, the media reporting was really scary. So the reality is that led to that settlement culture for silence. But the reality is the people that make the paper are politicians, CEOs, high profile people, sports people. So there's a bit of a formula of where the media goes, who they're out to get. What I would say is that's not the everyday experience, and Me Too's been really helpful to just get this as a dinner party conversation for people to understand. But whilst I don't think media should be the solution, I absolutely don't think it's helpful that media sort of brings up one case like that's the only law firm that's bad and it's that bad bloke, because that doesn't reflect the systemic nature. We know, I would almost be certain with when AMP was being reported, a whole lot of other banks were holding their breath really nervously thinking at least that's not us. But we know the systemic nature. But the media reporting has been important to move this conversation forward. And so whilst I don't want anyone's lives to be destroyed, because individuals who are in those cases say that there's some really heartbreaking stories over time of women whose lives have been ruined because of the media reporting. So we read it and it can be a double-edged sword. But I'm really clear. I can see I'm really keen for them to report by industry, but those big cases do capture the imagination. Weinstein made change. I think the High Court story, and I won't comment on any of these cases because I can't and I don't know any details, but it definitely started a conversation in the legal profession that, you know, has been long overdue. And so in some ways, I think I don't want these to be the normal. I hate that there's stories, but every now and then it really does mobilize the public outrage and also educate the public on just the nature. So I don't think it's even the scope. I think people need to know it's not just privileged people or celebrities. It happens to, you know, the rural migrant workers in the fields. It happens to everyone.
I guess it's just the tip of the iceberg. Final question from me. I had a lot more questions. We could talk all night on this, but final question for me is you delivered your report. It was tabled to Parliament in March. I think there was some news in the budget last night. What's the government's response been? You know, what can we expect?
Yes, so it was tabled by the Attorney General on the 5th of March, and then we all know what happened. So between then and now, really, I flipped what I thought I was going to do, and it's worked just as well, to do lots of education, lots of engaging with business, those who've been able to have some time to think about the report have been really reaching out. The government hasn't given its full response. I don't know when that will be, but in the budget last night, they did allocate $2.1 million over 3 years, and that is directed towards 3 key recommendations. So it's really encouraging, and they have been really supportive of the work at all times. So that's a Workplace Sexual Harassment Council that brings together those regulators to work together more consistently, a place to bring together best practice educational resources, and also funding for the next national survey in 2022. So it's almost here. So that's fantastic, and they are still considering the other recommendations.
Great. I'm pleased to hear that. We've had some great questions come in, and if you have any more, to type them in now in the remaining 13 minutes. We have one that's come in from someone who works in workplace investigations and have asked, I guess one of the challenges here is procedural fairness, fairness to the alleged perpetrator versus the impact investigations have on targets of this conduct. You know, the question asker wanted to know, you know, what does a target-focused, victim-focused approach mean in these sort of investigations when you think of things like standard of proof, procedural fairness, etc.?
Yeah, and I'm not for a minute suggesting there shouldn't be procedural fairness, but I do really say the safety obligations apply for both, you know, all employees, and I don't think the welfare of the individuals, it hasn't really been considered as a primary thing for investigators, or, you know, kind of, whilst you might say you okay, you know, doing an investigation with the welfare of individuals in mind just isn't how lawyers have traditionally worked. There's one or two things. There was a case study example in there from the AFL, which so I reviewed with a group their respect and responsibility policy a few years ago, and we recommended, so what would happen is it was off the back of yet another high profile incident of a player in a public space, and someone had made a complaint, and at the time Gillon McLachlan sort of came to me and said, could you review this policy, because we really want to help, but you know, he had a file this big, he said, but I feel like sometimes actually we make it worse. And that's absolute, you know, we think we're doing exactly that process. So they had in their integrity unit really well-trained people. And so in that, we did recommend the victim-focused, victim-centered approach. And there's a couple of principles in that, but there are really good people, and police do this for their external practice. So there are good people around who can teach you about a trauma-informed approach. But one of the first things I'd say is and I used to not say this as a lawyer, but, you know, ask the people what they want, because there's two things here. Quite often people aren't looking for, you know, it's very much the employer who's saying, we've got to give this person a warning or we've got to sack them. But actually, sometimes that's simply not the appropriate outcome. So I'm breaking all the rules by saying sometimes if you wouldn't sack the person, maybe you don't need to go through a whole major process. Maybe this doesn't need a full investigation like you do. So that's the 0 to atomic. There are some cases, you know, think of some different options, or if someone comes forward, you don't need to do it at all, just do some training, look around, start taking a different approach. But in terms of those investigations, definitely the delays make a huge difference to people's mental health and their careers. I would also say a bit more of a focus on the impact on all the players over time. So there's very much this view of we've done it, we've finished the file, let's put it in the confidential filing cabinet. And the number of times I heard of victims who just ultimately left. They didn't get the career options. And, you know, it was a bit controversial, so it didn't go in there. But I was like, I would want employers to track 3 months, 6 months, 12 months. What happened to that person? Did their career go off the rails? Because if you can keep their career on the rails, wow, that's amazing, because sexual harassment will happen to some people. There's a few different things, but there is definitely a conversation to be had, and I would say to seek that gender knowledge and some better gender expertise, rather than just stick to the old discipline of kind of what's a really good investigative legal cross-examination.
Thanks, Kate. We've had a question about, I guess, the economic dimension of this. Your research, my research showed the toll that this takes on the economy, on workplaces. And I think we're seeing probably with AMP more of a focus on, you know, the share price impact that allegations like this have. In your engagement with boards, with CEOs, are you beginning to see them look at issues like this as KPIs, as performance metrics, as things that will hurt their bottom line and equally can be mitigated and prevented, and that will help the bottom line?
Yes, absolutely. That's a simple answer, yes. And I recently did a webinar with the Australian Institute of Company Directors. We do specifically say boards should be trained and engaged in understanding this. There's a couple of things that I've seen, not all boards, but some have really, you know, if you just read the newspaper, I mean, boards have to adapt, and there is definitely issues to deal with in terms of not just sexual harassment, but also ethical conduct, cultural reform. It's been very topical with the Banking Royal Commission, and we had the ball tampering scandal. Like, there were so many things that kind of all point to the same kind of things, and also ask questions about how do boards know. The conversations I've had with boards about what they might ask for, because then their next question is, we're not meant to get involved in management. You know, this is, if you think this is an idea of just individual misconduct, then you'll think I shouldn't be involved. But the questions are about gender equality. What sort of priority as a broad organisation are you putting on that, and what does that look like? Second, a bit more of a safety kind of lens. What is the systemic trends? What, you don't need to know individual cases, but you should be getting, like a couple of board members have started demanding to know non-disclosure agreements, not the details, but tell us if we've got them, why have we got them? And then the last area that they do need to focus on is they need to focus on the CEO and the board. So there, in terms of that high risk reputation, some of it is productivity, but some of it is reputation. And at the most senior levels, boards need to accept that there is much higher risk if your CEO is sexually harassing someone than if some of your staff are. So you mightn't need to know how that's dealt with, but you do need to know how this one is being dealt with. So there, but my main comment to them is not that it's not as simple as find out the numbers of complaints, because we know only 17% of people who were sexually harassed in the 5 years to 2018 raised complaints. We know that's consistently low. And sometimes if you ask for complaint stats, everyone then says we need to make sure we've got no complaints, so it can drive the problem underground. So there's some more nuance in what you want to know.
I think that's a really important point. The IBA is committed to doing our survey again in a few years' time, and something that I've flagged is our numbers could go up And that wouldn't be a bad thing. But if if we normalize these issues, people are more willing to speak up and record their experience. And that may mean more reports and higher prevalence data. And how you square that with an improvement is a challenge. A few more questions, and then I promise we'll wrap up on time. Interesting questions come in about insurance. This person says that in one jurisdiction, employers are struggling with increased insurer intervention around safety issues, particularly bullying, which is perhaps attempted to avoid financial risk without trying to address the broader problem. Are we seeing a sort of insurance sort of interplay in the harassment space? We're seeing more insurers engaged here, and is that positive or negative?
So it didn't come up really that much in our inquiry, but I spoke last year, I think whenever I could get out of my house, to an insurance professional body, and they were really interested in what sort of things they should ask for from their insured to get some assurance about what was happening to reduce that risk of sexual harassment. And I haven't followed up, but at the time they were really quite progressive and quite constructive in what they were thinking. You know, they're looking for problems to help their insured not muck it up. And so it is relevant. I don't think, certainly when I was practicing, you couldn't get insurance for this sort of work. I know you probably can now. But I think the public, because of that reputation and the change in the public and investor expectations, that it's not as simple as insurance and who's paying and is there a way we can reduce the cost. It's more complex than that now.
I think a consistent theme of this discussion has been leadership, and whether that's from individuals, whether that's from organisations or sectors. At an individual level, leaders of organisations, how have you found, what strategies have you used to get buy-in, to get sort of hesitant leaders to engage and champion this issue?
Yes, great question. Well, one of the first things when I was going around, I sort of heard lots of stories of sexual harassment, and then there are sometimes, I'd say, okay, think of a workplace where, you weren't sexually harassed. What was present there? And it was always about a respectful culture and a leader, usually direct line, that I know I can talk to and who has set they never once said a good policy. And they actually, a bit like that training, they never once said 2 years ago, I did a really good online training course. So the reality was it was about leadership. Now, at all levels, I come back to, particularly with male leaders, that fear of talking about this topic. So I guess I started a really base level and say, kind of find a way to be able to talk about this topic, however that might be. And it's not something that you can outsource to an external trainer or HR. This is about you talking to your staff about a range of things. So I've done I did a briefing recently with a law firm and the partnership group, and I think they had a light bulb that, firstly, to your question, that this wasn't all about rape. There was the daily stuff, and it is happening. But two was me just saying, and I know on our website we did a conversation toolkit, but just saying, if you see something in the paper, or if there's, there's plenty of shows that you can talk about, just do it like you would do safety briefings. It's just a toolbox talk. It's a small thing. It's not a major thing that when you talk to your staff, just reinstate your position. Now, some of the fear is about not whether they'll have a false accusation, I've got to say, but about their past. Like, there's no question that I'm getting that, yes. But so having an ability to say, I mightn't have always got this right, but I'm learning, but actually it's really important to me. This is a respectful workplace, and it's really important you feel safe to speak to someone. It doesn't have to be me.
My 2 cents on leadership, what I found most important were the data that we had, which you can't argue with. I mean, people tried, but it's really hard to argue with empirical research about prevalence. And then the corollary of that was the stories that we had. We were we didn't intend to originally, but we asked people to tell us their stories anonymously as part of our research, and sharing those with CEOs, with managing partners. had an incredible impact. Final question from me, and keep it short because I need to wrap up. You know, you've worked in this area for a very long time. You're doing groundbreaking work. Are you optimistic about the future and a future in Australia where people can go to work and not worry about being sexually harassed?
I am. I think we're at a turning point. I think there's those combination of things all coming together. But having said that, I am not for 1 minute assuming it will just happen. I think there will be lots of people that will need to get involved. In fact, everyone, men and women. But I feel like there's a whole range of factors that mean we're going to have much better workplaces going forward. And I think that's to everyone's benefit.
Fantastic. Well, thank you, Kate, so much for your time. Thanks again to Margaret, to the team at the ANU College of Law for arranging this, and to everyone who's attended. And I guess my final comment to everyone, you know, Kate's mentioned the important about conversation, about, you know, having this dialogue, breaking the silence that surrounds these issues. So I'd encourage you tomorrow, you know, when you're speaking to a colleague or a friend, tell them about the webinar you attended the prior evening, and talk to them about, you know, what was discussed, and have a conversation. I appreciate that can be confronting, and saying to someone, I want to talk about sexual harassment can be very full on, but I'd encourage you to all play a role in continuing this dialogue. So thanks, Kate, and thanks to everyone for attending.
Thank you.